Hi, and welcome to this latest immigration law update video. In this video, I'm going to do the 11th video in my series covering the Upper Tribunal reported decisions for 2020, and we're looking at the decisions for November 2020. There were 4 cases, 2 involving issues of country guidance, one in looking at the question of historic injustice in Article 8 cases, and one looking at deportation. There's some very long head notes indeed. So I put the slides on the Number 8 website and I put the links to the cases below this video. So let's crack on. Fortunately, a short head note with the first one, NRS and another, NA Libya in Scotland. This concerns the publication of country guidance decisions which come out after a judge has written their decision. So in this case, there were 2 appeals before the Upper Tribunal, both involved Iraq. And whilst the determinations were waiting to be sent out, SMO, the new country guidance case, came out. So Mr. Ockelton looks at the status of country guidance decisions in section 107.3 of the 2002 Act and paragraph 12 of the practice directions. And he finds that NA Libya, which is an England and Wales Court of Appeal case, should be followed also in Scotland. No reason for any different approach. And the key date is when the decision is sent out. If a country guidance has been published before a decision of the tribunal is sent out, it impacts that decision. So in these cases, the decisions were set aside and remitted back to the first tier tribunal, in fact, back to the same judges, because there was no challenge to their findings of fact, because SMO needed to be considered, because even though they'd written their decisions before it came out, it hadn't been sent out. And the sent out decision, Mr. Ockelton finds, provides legal certainty. So that's the case of NRS. Let's have a look at the case of Patel involving Article 8 and Part 5A of the 2002 Act and the question of historic injustices. This involved an appellant who'd entered in 2010. She'd initially been here as a Tier 4 migrant, then as a Tier 1 PSW. And she'd encountered then later problems with her employer. That had led her to take a case before the Employment Tribunal, which I think was successful on a breach of contract point, but not on a discrimination point. And in her Article 8 appeal, it was argued that she'd been victim of a historic injustice. That had been dismissed by the first tier tribunal, and there was an appeal to the upper tribunal, and it came before the president. And the president starts his decision by defining historic and historical. So historic, he says, it is defined as something that is famous or important in history, whereas historical is just something that has happened in the past. So he finds for the future, the expression historic injustice as used in the immigration context should be reserved for cases such as those, so giving examples now, concerning certain British overseas citizens or families of Gurkha ex-servicemen, which involve a belated recognition by the United Kingdom government that a particular class of persons was wrongly treated in immigration terms in the past, and that this injustice should be recognised in dealing with applications made now. So it refers back to Patel, which I think is the special voucher case, and also AP India. So the fact that the injustice exists will be uncontroversial. It will be generally recognised. It will apply to a particular class of persons, unlike cases of what might be described as historical injustice. So he makes the distinction. The operation of historic injustice will not depend on the particular interaction between the individual member of the class and the Secretary of State. The effects of historic injustice on the immigration position of the individual are likely to be profound, even determinative of success, provided there is nothing materially adverse in their immigration history. And actually, at paragraph 40, he says we may see Windrush cases under the historic injustice category in the future. So he goes on then to look at historical injustice, cases that may be described as involving historical injustice where an individual has suffered as a result of the wrongful operation or non-operation by the Secretary of State over immigration functions. And again, he gives examples. So examples where the Secretary of State has failed to give an individual the benefit of a relevant immigration policy. Looks at IAA Afghanistan there, where there's delay as a result of a dysfunctional immigration system, EB Kosovo, or where the Secretary of State forms a view about an individual's activities or behaviour, which leads to an adverse immigration decision, but where her view turns out to be mistaken, and looks back at the Asylum case. Each of these failings may have an effect on an individual's Article 8 case, but the ways in which this may happen may differ from true historic injustice categories. So there's these two categories, historic and historical. One's about a class of individuals, one's about individuals themselves who've suffered injustice. So in terms of then the effect on Part 5A and the weight to be given to the maintenance of effective immigration controls, he says this, and this, have a look at paragraph 84 of the judgment. In all cases where, for whatever reason, the public interest in the maintenance of immigration controls falls to be given less than its ordinary weight, the usual course should be for the judge to find in terms when addressing section 117B1 of the 2002 Act. That's the section that says the maintenance of immigration control is in the public interest. However, the same result may be achieved, at least in some situations, by qualifying the consideration in section 117B4 that little weight should be given to a private life formed when the person concerned is in the United Kingdom unlawfully. So you could do it by section 117B1, maintenance immigration control is in the public interest, or maybe by qualifying the little weight provision. Judicial fact finder should, however, avoid any recourse to double counting, whereby not only is the weight to be given to effective immigration controls diminished, but also for the same reason a private life is given more weight than would otherwise be possible by the undiluted application of section 117B4. This section and 4 of the head note, which is paragraph 84 of the judgment, so just chided with me a bit because of what was said by Lord Bingham in EB Kosovo in relation to delay, that delay can operate to reduce the public interest, and during the period of the delay, somebody's Article 8 private and family life can be strengthened. So it does operate on both sides of the balance. Now, I'm not saying that I've reached a concluded view on this, but when you're looking at this case and Patel and head note 4, paragraph 84, do consider what Lord Bingham said in EB Kosovo about the way delays can affect an Article 8 claim. Finally, the weight to be given to the public interest in the maintenance of effective immigration controls is unlikely to be reduced because of disappointments or inadequacies encountered by individuals from teaching institutions or employers. And that was the case in this case. And the first-tier tribunal decision dismissing the appeal was upheld by the upper tribunal. Again, back to country guidance issues, and this is a country guidance case, PK and OS, in terms of Ukraine. These were Ukrainian nationals who were obliged to perform military service, and their argument was that the Ukrainian forces engage in acts contrary to the basic rules of human conduct, and that engaged the Refugee Convention and Article 3. PK itself was a case remitted from the Court of Appeal. So apologies for the slides because there's a huge amount of text in the head note, but let's have a look particularly at section 1 of the head note, acts contrary to the basic rules of human conduct. Where a person faces punishment for a refusal to perform military service that would or might involve acts contrary to the basic rules of human conduct, that is capable of amounting to being persecuted on grounds of political opinion. So engage in the Refugee Convention. Acts contrary to the basic rules of human conduct refer to the core humanitarian norms generally accepted between nations. Krotov, it gives examples. In order to engage, the Refugee Convention, the conduct in question must be committed on a systemic basis as the result of a deliberate policy or official indifference to the brutal military. It is not necessary for there to be specific international condemnation of the conflict in question. However, where there is specific international condemnation of the action, that's likely to provide an evidential basis for concluding that it's reasonably likely that military force in question is engaging acts contrary to the basic rules of human conduct. Individual concern must demonstrate, F, that it's reasonably likely that their military service would involve the commission of acts contrary to the basic rules of human conduct, or that by performance of their tasks, they would provide indispensable support to the preparation or execution of such acts. Political opinion of the person concerned must be to oppose the commission of acts contrary to the basic rules of human conduct. Unlikely it's going to be necessary to do significant evidence rather than just opposing such conduct. But if you've voluntarily done it in the past, that might cause difficulties and probably will cause you to fall foul of the exclusion clauses of the Refugee Convention. H must be no other way to avoid military service through conscientious objector process, for example. And where a causal link exists between the military role of the conscript or reservist, the commission of or participation in acts contrary to the basic rules of human conduct, and the punishment, if it includes a fine or non-custodial sentence, that'll be sufficient to amount to persecution as long as it's more than negligible. Then they go on to give country guidance on the conduct of the Ukrainian military in the conflict in the anti-terrorist operation zone, and looked at the acts of the Ukrainian military in that area. But then at 3, they look at the country guidance for conscripts or mobilized reservists. And actually, conscripts and mobilized reservists are not sent to the anti-terrorist operation zone. So it's not reasonably likely that they're going to provide support for the work and the atrocities that are going on there. So unlikely that you're going to succeed on that basis. Have a look at section 3. So a very long judgment, but section 1 is very important because it applies beyond Ukraine and to the whole concept of when you have to perform acts that are contrary to the basic rules of human conduct. Finally then, Wilson. Really interesting case, actually, and as I delve down into it, it raises some really significant issues. 2 main points. First is about section 117D and an offence that has caused serious harm. And secondly, the relation between deportation decisions and human rights appeals. So this appeal concerned an individual who had a conviction for carrying a bladed article in a public place, namely a lock knife. Now, under section 117D, there are 3 ways somebody can be a foreign criminal: a sentence of 12 months or more imprisonment. Secondly, an offence that's caused serious harm, which is what was argued in this case, or to be a persistent offender. The first-tier tribunal judge had found in this case that the Secretary of State had not established that the appellant's offence of carrying this bladed article in a public place was an offence that had caused serious harm, and therefore went on to allow the appeal on Article 8 grounds. And the judge didn't go through a sort of proper proportionality assessment going through all of Part 5A of the 2002 Act, and relied on the upper tribunal decision in Charles, which we'll come back to. So the president in this case reviews the authorities firstly on offences that have caused serious harm. There are 3 leading authorities: LT Kosovo from 2016, SC Zimbabwe from 2018, and Mahmoud from 2020, all decisions of the Court of Appeal. And so he sets out in the head note, whether an offence has caused serious harm is a matter for a judge to decide in all the circumstances. As long as a judge has considered all the relevant factors, not had regard to irrelevant factors, and not reached a perverse decision, it's not going to be an error of law in the judge's conclusion. In determining what matters are relevant or irrelevant, you should bear in mind the following. Secretary of State's view is the starting point. Sentencing remarks should be carefully considered, not least what's said about whether the offence caused serious harm as categorised in the Sentencing Council guidelines. Victim statement adduced will be relevant. Whilst the Secretary of State bears the burden of proof, they don't need to adduce evidence from the victim at the appeal before the first-tier tribunal. The appellant's own evidence on the seriousness will usually be treated with caution. Serious harm can involve physical, emotional, or economic harm, doesn't need to be limited to the individual. But importantly, look at G and H. The mere potential for harm is irrelevant. So just because carrying a knife in a public place has the potential to cause harm is irrelevant. And again, the fact that a particular type of offence contributes to a serious widespread problem, such as knife crime, is not sufficient. There must be some evidence that the actual offence caused serious harm. So in this element, the upper tribunal found that the judge did not err in law and upheld his decision that the offence didn't cause serious harm. And they didn't allow the Secretary of State to amend her grounds to try and then say, well, in the alternative, the appellant's a persistent offender, because the decision had not been made on that ground. But the tribunal did allow the Secretary of State to amend her grounds in relation to the judge's approach to the human rights appeal, because the judge effectively said, well, he's not a foreign criminal. Following Charles, I allow the appeal. It's disproportionate and didn't go through properly Part 5A of the 2002 Act and conduct a proper proportionality assessment. And the president says, in a human rights appeal, the decision under appeal is the refusal by the Secretary of State of a human rights claim. So he goes back to the definition of a human rights claim under section 1131 of the 2002 Act. So it's an appeal against the refusal of a claim that removal from the United Kingdom or a requirement to leave it would be unlawful under section 6 of the Human Rights Act. The first-tier tribunal is therefore not deciding an appeal against the decision to make a deportation order or the decision that the removal of the individual is, in the Secretary of State's view, conducive to the public good. So obviously the Secretary of State can deem under section 3.5 of the 71 Act that somebody is liable to deportation. It is concerned only with whether removal, etc., in consequence of the refusal of the human rights claim is contrary to section 6 of the Human Rights Act. If Article 8.1 is engaged, the answer to that question requires a finding of whether removal, etc., would be disproportionate interference with Article 8 rights. And then 2, the Secretary of State's decisions under the 1971 Act that P's deportation would be conducive to the public good and that a deportation order should be made in respect of P would have to be unlawful on public law grounds before that anterior aspect of the decision-making process could inform the conclusion to be reached by the first-tier tribunal in the human rights appeal. So in Charles, what they'd found is, under section 7 under the 71 Act, that because of when the appellant had arrived in the United Kingdom, he wasn't liable to deportation, and that was a relevant consideration. But in this case, just because the appellant wasn't a foreign criminal doesn't mean the tribunal doesn't have to then properly consider the human rights appeal, making proper findings as to whether removal would be a disproportionate interference with Article 8. So some really interesting points there in the second half of the decision, looking at deportation decisions and human rights appeals, which is something to be aware of. You can't just rock up and say, well, you've got it wrong, he ain't a foreign criminal. You're still going to have to then go on and consider and argue that removal would be a disproportionate breach of Article 8. So those are the cases for November 2020. I hope that's helpful. I'll put my slides on the Number 8 website. I'll be back with the final video covering December 2020 once the tribunal have promulgated all the decisions for that period. So thanks a lot.